case number 118742 in the matter of Zane Todd Jr.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, may I have 2 minutes in rebuttal, please?
2 minutes is granted.
Thank you. On July 22nd, 2014, the respondent signed a diversion agreement. In the agreement, he stipulated that he failed to timely communicate and promptly investigate an inmate's claim about jail time credit. That led to a stipulation of a violation of 1.3 and 1.4. The diversionary period was for a year. One of the requirements was that he was to complete 16 hours of CLE, including 6 hours of ethics. He did not complete the required hours within the time frame.
Missing only one, correct?
Correct. He was advised in writing that he was missing the hour. He was given 6 months to cure the issue. During that period of time, he was to pay the $50 monthly monitoring fee that had previously been waived. He didn't respond, he didn't pay the fee, and he didn't provide proof of the completed hours.
Was that the time when he became ill, or was that
He was
later?
ill during the time. The reason he couldn't get his hour was that he was at KU Med, but I didn't know that. My letters weren't coming back undeliverable, so I just, from my perception at that time, we had an individual that literally had just fallen off the radar. He was advised that his diversion was going to be revoked. He was afforded an opportunity to respond whether or not it should be revoked. He was given 20 days to do that. He didn't do that. There was a formal...
Didn't respond.
Didn't respond.
And all this time, is this the time period when the address may have been incorrect? Isn't this the case that had a problem with delivery of notice because of a change in an office number in a building?
I'm not sure if it was this issue or the second notice of the hearing that was the address. I apologize.
Okay, so
Second.
you just don't know the answer about whether that problem was also occurring during this time when he was not responding.
Correct.
Okay, thanks.
I do know that he did receive notice of the formal complaint that was subsequently filed.
Okay.
And he didn't file an answer to that. And we learned at the hearing the reason he didn't file an answer was his intent to acknowledge the misconduct, to admit to what he had done, and apologize. And it was during the hearing for the first time that I found out about this significant health crisis. And it was really sad and compelling testimony. I mean, it was an hour of CLE, and there was some discussion about, I got your letters, but I'm at KU Med, what am I going to do? I can't get up and go and do it. So I asked for the hearing to be stopped, for him to go speak with KLAP to see if there was any continuing ongoing issues that might contribute to additional misconduct, and my intent was to request that he be placed back on diversion. And we were both to file a status report after this had happened. My status report indicated I hadn't heard anything from him, and in fact my status report was late. After that, on April 4th, Ms. McDonald sent a letter saying that he had indeed sat down and met with him. They had reviewed all of the services that KLAP has to offer, and he really wasn't a potential client. There wasn't really any need for him to have services. On April 11th, I sent that letter to Mr. Todd and to the panel, and in that I said, quote, I received this from Ms. McDonald. I accept this as the answer to the panel's request for a status report. And then there was a continuation of the hearing on May 8th, and Mr. Todd didn't appear for that. And after the hearing, I called him.
I'm confused about why that second hearing went forward. If KLAP said there's nothing we can do to help him, you described what had been told to you before as sympathetic and compelling. Mm-hmm. I mean, at that point, why didn't this whole train stop?
Because the panel needed to give direction as to what the disposition was. His diversion was revoked. He wasn't on diversion.
He couldn't be put back on diversion?
He could, but I don't have the authority to do that.
But at the panel hearing, you ended up advocating for suspension.
I did, because he didn't show up and I didn't know what else to do. I never had a situation that the intent was to go back. My intention for that second panel hearing was to stand up and say, he's talked to Caleb, there's nothing more we can do. Let's put him back on diversion. He can get his hour, and then we'll successfully discharge him. And then when he didn't show up, and I didn't know why he didn't show up because I had literally no contact with him. I mean, Ms. McDonald was the one that sent the status report. It didn't come from him.
And the second panel hearing did follow a period of time when there was some confusion about his address.
He testified that he did not receive notice of the hearing.
Okay.
And so then after I called him, he was surprised that we had had a second hearing, and he made a request to reopen the record to finish it out, which I didn't object to, and he did, and we had a secondary hearing. And because part of the confusion was my language, in the second hearing, he suggested that it was his understanding that because I accepted his status report from Ms. McDonald, that somehow he got put back on diversion. And as we've had this exchange, I didn't have that power. Only the panel could do that.
But at that hearing that eventually did happen with him present, you advocated for suspension.
I
rather
did.
than putting him back on diversion, even though you understood all the confusion that had
I did.
happened before.
And a lot of it was because at some point it seemed to me that he wasn't reading the rules. That he wasn't asking questions. I appreciate the fact that he was a solo practitioner, but it seemed to me that it would be reasonable to at least make a call saying, do I have to come to the second hearing? Is everything good? Am I back on diversion? I haven't gotten any paperwork from you. And we talked about it, and honestly, I didn't know what else to do at that
When you say
point.
we talked about it, you're talking about internally at the
Yes.
disciplinary administrator's office. You didn't place a call to him and say that it was my intention to advocate for diversion. You didn't do that either. You didn't call him.
I called him after the second meeting and asked why he didn't show up, and advised that my recommendation was for a suspension because he didn't show up. And we had a discussion about how to reopen the record and how to get this so that everything is out in the open and things could be put back. But after he didn't show up the second time, no, I did not advocate at any time to have him put back on diversion.
What are you asking us to do today about the respondent?
I believe that the hearing panel, well, first of all, with Mr. Todd's permission, I did contact Judge Moriarty in Johnson County, and he advised that he is currently still taking the difficult cases, still taking the difficult clients, and he's still doing a really good job, and he is of value, a significant value to the Johnson County Bar. I think the panel correctly concluded that there was significant mitigating factors. There was confusion, as Justice Breyer pointed out, and they recommended a censure. And at this point, I would concur with that, and I would ask for a public censure.
Did you have any more facts you wanted to relate, or you think that's sufficient?
I think that's sufficient, and I also think the panel did a really good job of laying out all of the procedural complexities that this case presented.
Do we have any questions of counsel? Thank you, counsel.
Thank you.
Thank you, Zane Todd, representing myself. I believe that I agree with everything that was presented. I did receive a letter from a client advising he thought his jail credit was incorrect. I responded with a letter that said, I think that you might be right based upon what you've told me. I will look into it. I found out there were a number of cases, and so I was waiting on some information, and I didn't promptly respond to him after that first letter. I did go on the diversion, was required to have 16 hours. At the June ending point, I was diagnosed with stage 4 throat cancer, and at that point in time, I essentially shut my practice down. As far as clarification to the address issue, at that point in time, I did receive those letters. Those were brought to me at home or while I was at the hospital, and I was informed that I was in violation of my diversion. I knew that I was. I, in hindsight, should have sent an email and said, I'm sick, give me some sympathy and extend that, but I did not. At that point in time, I'll be honest, that was not the highest priority in my life. I have 2 kids starting college, and a lot of debt piling up, and so I did not contact them. Then we did have a meeting. I was advised to contact KLAP. I had called them early on in my diagnosis, and they advised me that they were really designed for attorneys with some sort of a substance abuse problem, and not for someone with this diagnosis. Subsequently, they have got a program into that, but at the time they did not. After the first hearing, I was advised that to meet with KLAP, and I called them and met with them in person shortly after that. I didn't realize that I was required to sign a waiver before they would send in a report. I did get a letter advising nothing had been done. I contacted KLAP and did a waiver. Shortly after that, I received a letter and an email from the disciplinarian saying, "This will suffice." At that point in time, I didn't hear anything else. A month or two passed, but this procedure had been glacially slow, so I didn't know when to expect something from them until I got a phone call advising that there had been a hearing earlier that day. Why wasn't I there? I didn't have any notice of that. I did explain that I work in a building with, at times, 20 lawyers, and they all fit into a set box, and perhaps the letter came there, but it wasn't a certified letter. I just didn't get that. I was back in my office, and I am back in practice now. So I asked to reopen, and I went forward, reopened the case, and came back and just asked that the panel do what they do. I advised that I did mess up by not completing those hours, and that I should have contacted them advising that I was ill, and that was the reasoning. But as I said before, at that point in time, I couldn't speak. I had essentially turned my practice over to a number of attorneys, and I did get those letters advising, and I knew that I hadn't turned in that last hour. I failed to do that. Thank you.
Do we
Any
have
questions?
any questions? All right, does that conclude your presentation?
Yes, thank you.
What are you asking us to do?
I will take anything the court gives. I acknowledge I made a mistake.
Thank you, counsel.
Thank you.
I would waive rebuttal unless there are any other questions.
Any questions? I see none. Thank you, counsel. Thank both of you for your arguments this morning. Court will take this matter under advisement.